going to go ahead and get started. It's 4:30 and this is a very timely event, so I'd like to say welcome. We're glad you could make it to today's S.T.I.R Talk. S.T.I.R Talks are a new event at Nebraska Law. It's pretty exciting. You get to hear your professors talking about what they're doing research in. My name is Marcia Doherty Baker. I'm the Access Services Librarian at Schmid Law Library. It's nice to see you outside the classroom and outside the library. Very glad you could be here. It's my pleasure today to introduce Professor Jess Shoemaker. Her talk is entitled, No Sticks in My Bundle, the Indian Land Tenure Problem. Professor Shoemaker joined the law faculty in 2012. She received her BA degree in English from the University of Iowa and her JD degree from the University of Wisconsin Law School, where she also served as an editor for the Wisconsin Law Review. Professor Shoemaker clerked for the Honorable David M. Ebel in the United States Courts of Appeal for the 10th Circuit. Following her clerkship, Professor Shoemaker was awarded the prestigious Skagen Fellowship to work for Farmers Legal Action Group in St. Paul, Minnesota, on a range of legal issues affecting farmers and rural communities. After that, Professor Shoemaker spent 5 years as an attorney in Denver at Arnold & Porter and worked on litigation in several different courts, including the United States Supreme Court. She has experience in nearly every phase of dispute resolution, from pre-complaint counseling to appeal, and over the course of her career, she has represented Indian tribes, entrepreneurs, energy developers, and farmers. Professor Shoemaker teaches federal Indian law, and this semester she is teaching a rural development seminar. Her research focuses on rural land tenure, Indian land tenure, community economic development, agriculture, and energy. She is also participating in the University of Nebraska's efforts to establish the Rural Futures Institute. Prior to her legal career, Professor Shoemaker was a writer, a Vista volunteer, and a community organizer. And it's my pleasure to introduce Jess to the podium.
Thank you all for coming. I thought it would be fun, in addition to introducing the gong and the suspense of the gong, if I go over time, to have laryngitis as well, so that we could see if my voice will actually hold up for the whole 15 minutes. But hopefully this mic will work and you can all hear me and we will get through it together. I also wanted to, at the start, thank my research assistants. Ellen McKitterick is here, and Milt Nicholson, who couldn't be with us this afternoon. But both have been super helpful to me in researching some of the topics in this talk throughout the year. They taught me how to use a Prezi, which is really important for today. And they've also just been great fun to get to know and work with over the course of the year. I also want to thank Diane Amdor, who agreed to be our first-time gong ringer, which hopefully we won't need to use it today, but she's there and ready if we do. So Diane, you can start timing now. Today I want to talk about a topic that I think is really fascinating but also really important, and that is the special set of property rules that apply exclusively to Indian lands and Indian landowners, and particularly how I think these property rules adversely impact the social and economic opportunities in Indian communities right here in Nebraska and in the Great Plains and beyond. Now, I don't want to make any presumptions about anyone in this room, but I will say that generally, most people, including most highly educated people, for those people, generally there's some sort of sense of mystery or uncertainty about exactly how the law operates when we cross the border into an Indian reservation, and especially how property law works within a reservation. We may have heard something about the trust status of Indian lands and the fact that most Indian land is held in trust by the federal government, but the precise parameters of and reasons for and implications of that trust status and that trust relationship may be a little more fuzzy. So my primary argument is that the special property rules that apply to Indian landowners are at the root of many of the social and economic issues that we see on many reservations today. Poverty, unemployment, housing shortages, lack of basic services, even health and safety concerns. In other words, a lot of these stem from a fundamentally legal problem with a potential legal solution. So what do I mean when I refer to these special property rules And what's my basis for this relatively incendiary title, suggesting that many Indian landowners, although they're truly technically landowners, own property subject to a special set of rules that effectively equates to owning land without holding any of the meaningful sticks in the proverbial property rights bundle. So we have essentially a sort of property law shell game, with Indian landowners bound up in a tenure pattern that prevents direct owner use and possession of what for many is their most important and valuable resource, their land. So in order to explain this, I have to start with a little bit of an explanation of the evolution of federal Indian law and the evolution of Indian property rights. So here we go, my attempt at a brief history of federal Indian law in 5 minutes or less. So we know, right, that before European contact on this continent, Indian nations were here first, right? And they were nations with their own respective territories and property rights within those territories. Sometimes I think it's easy to jump to the assumption that within respective Indian nations' territories it was sort of all common property held in common by the tribe, but in fact history and great scholarship has shown that in fact each tribe had its own sort of respective inherent property system and property institutions, including very sophisticated systems for individual property rights. So we know what happens next, right? Europeans arrive in the continent and we see a series of treaties negotiated between first Britain, then the United States, with Indian nations. And these treaties are really the primary legal instrument by which negotiations about who has territory or jurisdiction where were conducted. But they're also really real estate transactions in a large sense. So land outside of certain reserved territories would be ceded to Britain or then the United States, with tribes retaining in their reservation, in their retained areas, whatever rights pre-existed before that, whatever wasn't changed by the treaty. Now, a lot of these treaties were in fact mutual, peaceful, actual negotiations between two governments. But of course, we can't overlook that a lot of the motivation, at least on one side of the deal, was a desire for more Indian land. And so certainly not all of this history is conscionable or something we might look proudly on, and the Trail of Tears is certainly a sort of clear example of that. But because I'm doing the history in 5 minutes or less, we will suffice it to say that generally, through various treaties and agreements, some fair and some not, tribes did cede significant swaths of land to federal government, leading over time to a gradual decreasing in their land base until we get to present-day Indian reservations, with 6 tribes in Nebraska still today. Within these existing reservations, the original idea, right, was that these were reserved areas where tribes would be able to live, organize, and govern themselves sort of as they saw fit. We know that meanwhile, there's western expansion, homesteading going on, homesteaders, gold miners, railroads, all moving west, with an increasing sort of agitation at the idea of living among or near so-called savage Indians in the midst of these yeoman farmers. So ultimately, a group calling themselves the Friends of the Indians, who also happened to be evangelizing missionaries, asserted what they believed, and I think truly believed, was this benevolent idea that we would transform and assimilate Indians into sort of the American social fabric. And the really interesting thing is that the mechanism by which this assimilation was encouraged was through the transformative power of property. So the idea was, if we could make reservations, property systems look more like this, then Indians would look more like this, right? So Indians would become farmers. And so here comes allotment, which is this major federal policy from the 1880s and before, frankly, by which federal government decided to reach into reserved territories, reservations, and essentially place a grid-like federal property system over existing tribal property patterns and allot to individual Indian landowners a square piece of property. That would be their individual allotment. Now, these allotments were basically 40 to 160 acres. The idea was that Indians would farm them, become sort of westernized. But the allotments were held in a special trust status. So this is where we start with the idea of a special trust pattern of land ownership. So trust status at that time was meant to be sort of a probationary period during which individual Indian landowners would sort of become westernized and sort of be able to own property and fee like the homesteaders did. So land and allotments couldn't be alienated. There was no sale. There's no right to make a will. Basically protected from any kind of land loss. Now, you can't talk about allotment, though, without talking about the fact that in addition to allotting to individual Indians their 40 to 160 acres, whatever was not allotted to an individual Indian was deemed surplus lands and then opened up to homesteading. So a vast majority, 2/3 of Indian lands at this time, get lost to non-Indian ownership, even within reservation boundaries, because of surplus lands. And also when the trust status was removed on individual parcels, a tremendous amount of land loss empirically occurred because of speculators purchasing land from Indian citizens, tax foreclosure sales, and other reasons. So there's certainly a sort of land grab motive involved in allotment as well. But allotment goes on. In 1928, the federal government assesses sort of how we're doing with allotment and concludes it's a complete failure. Indians haven't become farmers. The government has started leasing property to non-Indians, and there was no land left, right, for new generations to spread out on. So what the federal government says is you created these dismal pockets of poverty instead of sort of this independent community that you were seeking. So in 1934, we stopped allotment. And so that brings us to today. There's no more allotment, but we do, here's a map of Pine Ridge, a reservation not too far from here, just north of us in the southern part of South Dakota. All the yellow land are individual allotments, so 60% of Pine Ridge is held by individual Indians. It's still held in trust, so that protected trust status gets perpetuated and continued for fear of losing more land, because so much land was lost. In the trust status, the BIA still maintains all the records, but also still prevents alienation, any sort of transfer of land without BIA approval and a formal appraisal. So every sort of land transaction becomes super cumbersome, right? Because there's this enormous bureaucracy involved and any transaction in the trust system. So the trust ownership itself complicates what bundles of, or what sticks in the property right bundles an individual Indian has. But the other thing that you have to talk about at the same time is fractionation. So fractionation is this condition that has occurred because of allotment, and we'll talk about that in just a second, where you not only within these little square parcels of individual yellow allotments on this map have just one owner owning the land in trust, now you have hundreds or thousands of owners owning it in trust together. So let's talk quickly about sort of how this occurred. So you start with one owner, right? You start with the original allottee. Now that person can't sell or transfer the land, can't write a will, and so when that person dies, it passes by intestacy to that same piece of property is then shared among the co-owners, the siblings, the children. Now that generation now shares what had just been one family's land. They still can't transfer or sell their land. They can't write a will until 1910 when that was permitted. And there's no more land left, right? There's no land within the reservation on which to spread. So even if you could sell, you can't buy land anywhere else in the reservation, at least not trust land. And so you see through generations of intestacy, just more and more co-owners sharing property within this trust system. So this is our second generation. You end up with 9 families. If you just continue with 3 heirs per family after 6 generations, you have 243 heirs sharing in that family, that single allotment. Now, the thing that's really interesting and kind of the focus of my research is thinking about the ways in which the trust restrictions, which are protective in a lot of ways, and a lot of Indian citizens prefer and want to keep these trust protections, have really sort of exacerbated fractionation in this co-ownership problem. So you can't, there's no exit mechanism, right? You can't transfer or alienate your property. There are processes now through the BIA where you can get a bunch of approvals in order to do so, but it's cumbersome, and you have to get a huge appraisal, and it can take years and literally years to do this. Wills are now also have to be approved by the secretary, but also there's no disincentives, right, to having a smaller ownership interest at this point. So unlike outside of the Indian context, there's no tax that you have to pay for having small interest. You don't have to do record keeping. The BIA does that for you. There's no risk of partition or land loss. And so there's really there's no way to get out, and there's no incentive to get out. And actually the BIA will lease your property for you if you are inactive. So if all the owners can't agree to do something, then the BIA will step in and lease your property to non-Indians or Indians, whoever the highest bidder is, at your choice. And the really interesting thing, and what my RAs and I have been researching for this year, is that the current rule, so if I own property with 200 people in fee in Nebraska, core property rights is that I would have one of my property right sticks in my bundle, is that I could make use of the entire property. And I had to kind of informally work it out with my co-owners, but the right to use and possess, sort of key, right? But in the Indian land context, what the BIA as trustee has said is that because the BIA the Bureau of Indian Affairs will lease it, then there's no owner use right anymore. So any of these owners can't make use of their property unless they go through a formal lease and appraisal process with the BIA. So if you can't go onto your property and access it, what are your property rights and what are the values of that? So fractionation is quite extreme. I'm going to skip through these numbers for time, but the Supreme Court has given examples of smallest heirs who make 1/100,000th of a cent if they were to sell their property. And the Government Accountability Office has said that in a quarter of the reservations they've surveyed, if you were to physically partition out the smallest interest holder, a quarter of the reservations would have interests that were smaller than the piece of paper on which the report was printed. So we're talking about 200 owners is sort of a good case, right? We see 500, we see 1,000. There's a lot of co-owners in a lot of these properties. So certainly that makes it hard to build housing on your property, to farm your property, to graze your property, and certainly out of the question to be able to use your property as any kind of collateral for land use. And so what am I thinking about, what am I doing, is trying to think about what are some sort of solutions or sort of next steps for this. There's been a lot of effort and attention paid to how could we consolidate these interests now that they're so extreme and so small, and that's certainly a valid, important effort. But you can math tells you, right, that as small interests get subdivided more and more, this problem grows exponentially over time. And so I'm trying to think more about what are changes we could make to make this a more livable situation as it is. So are there ways to return to traditional tribal norms of land use and owner's use rights within this fractionated land? Are there ways to incentivize landowner action instead of the current incentives that are for, if you're inactive, you will get more money essentially because the Bureau of Indian Affairs will do it for you. And can we sort of revise the trust status in a way that will make it more useful for citizens themselves? So I'm getting the gong sign. I will stop. But thank you so much for listening.